Yusuf Oluwafemi Salako, popularly known as Orji David, a 500 level law student of University of Lagos and founder of the Orji David Consorts. If you are new here, I say welcome to you. You may consider subscribing to our channel by clicking on the subscribe button down below and hitting that notification bell so you get notified whenever I put up new videos. Now click on the subscribe button, hit that notification bell. Now on today's episode of Law and Language, I shall not be teaching any topic, but instead I shall be passing one or two comments on the recent decision of the Supreme Court which voided the conviction of Senator Orji Kalu. This decision has engendered diverse views and it has even polarized commentators into two separate groups, those that are in favor of the decision and those that are not in favor of the decision. On a particular platform, I have argued that the decision is correct in law and in principle. However, in today's video, I will be talking about how that correct or right decision actually seemed wrong. Because in my humble view, the Supreme Court only took a comfortable and convenient path to arriving at that decision. So the first thing is to basically explain or summarize the basis in which the Supreme Court arrived at that conclusion. So the section 396 subsection 7 of the Administration of Criminal Justice Act allows a judge that has been elevated to a superior position to conclude pending cases while he has been elevated to this position. And this was what made Justice Mohammed Idris to conclude the case even when he had been elevated to the position of Justice of the Court of Appeal. Senator Orji Kalu and his team then challenged this on jurisdictional grounds. And their position is very clear. Since the Constitution has provided that for the Federal High Court to be properly constituted, there must be a judge of the Federal High Court. Because it says that a judge of that court. Now their contention, which was advanced before the Supreme Court, and which the Supreme Court agreed with, was simply that seeing as Justice Idris had already been elevated to the position as a Justice of the Court of Appeal, he was no longer a judge of the Federal High Court. And as such, going ahead with that case meant the court was not properly constituted. And if a court is not properly constituted, then that court cannot have jurisdiction. This strictness of law has been settled in an avalanche of cases in Kemdili and Madukalu, Wemabag versus Bronick Motors. And the court accepted. However, the court also held that section 396 subsection 7 of the ACJA is therefore unconstitutional because it tends to compete with the provisions of the Constitution, and pursuant to section 1 subsection 3 of the 1999 Constitution, it cannot stand. And the court brought its heavy hammer, its sledgehammer, and it struck out section 396 subsection 7 of the ACJA. But in today's episode, I also want to submit that it would appear that the Supreme Court took a convenient position. A convenient position that only gave us technical or legal justice as against human and social justice. The law is made by man for man. The Constitution, being an organic law, means that the Constitution must reflect the idiosyncrasies, practical realities of every society. When we say the Constitution is supreme, it then means that the people are supreme, because the Constitution is a codification of the will of the people. It is the sovereignty of the people that reflect the supremacy of the Constitution. So we cannot continue to just bandy constitutional supremacy and jurisdiction about without necessarily consider whether it will lead to the end of justice or not. When we look at the provision of section 251, which the court relied on, you find that section 251 actually said that the Federal High Court has jurisdiction on several matters. Also, when we look at section 253, which is the relevant section here, it says that the Federal High Court shall be duly constituted if it consists of at least one judge of that court. Yes, of that court. But we cannot read those words in isolation. We have to read them together. It said it is properly constituted if it consists of at least one judge of that court. At least means that one or more. It is then my contention that as against the position or the view of the Supreme Court that section 396 subsection 7 of the ACJA competes against the Constitution, I am submitting that it would appear that section 396 subsection 7 of the ACJA is actually complementing the Constitution. There is no way in the Constitution where it was stated that where you have been elevated from one court to another court, then you are barred from attending to matters that you are seized of as at the time of that promotion. It tells us that it would appear that perhaps the drafters of the Constitution never envisaged such a position. And if there is a lacuna in this regard, based on the legislative power that has been conferred on the National Assembly by the Constitution itself in section 4 of the 1999 Constitution, then the National Assembly can make a law in that particular regard. In fact, it can also be argued that perhaps the drafters of the Constitution actually contemplated that there is a possibility for a judge to perform dual functions. That is, that there is a possibility for a judge that has been elevated to another position to conclude the matters that he was seized of before that particular promotion. And this is so when one also take a calm view of that expression, at least one judge. At least one judge says that the Federal High Court will be properly constituted as long as there is one judge of the Federal High Court. It then means that there is a possibility, or that could be interpreted purposively and broadly to mean that as long as there is a judge of that court, there can be another judge from another court. Which then means that if this interpretation has been afforded to that particular provision, the court would have arrived at a contrary conclusion or decision to say that Justice Idris was only one of the judges, that there could also be another judge of the Federal High Court, because this would be in the interest of justice. Or perhaps another way of interpreting this could be to actually see Justice Idris Ibrahim to be a judge of the Federal High Court symbolically. And what I mean is this: as at the time that Justice Idris Ibrahim took on that matter, he was a judge of the Federal High Court. Then for the purpose of dealing with that matter, the Supreme Court could actually interpret this provision to say that in the eyes of the law, as far as that matter is concerned, Justice Idris Ibrahim was still a judge of the Federal High Court. This, I believe, would have actually taken us to the ends of justice. But to say that section 396 subsection 7 of the ACJA competes with the Constitution, I believe is taking matter too far and adhering to technical exactitude as against substantive justice. Because the Constitution also envisages that the National Assembly may by an act make laws on the jurisdiction of the court. And this is so when one considers section 251 subsection 1. It said notwithstanding anything to the contrary contained in this constitution, and in addition to such other jurisdiction as may be conferred on it by an act of the National Assembly. As may be conferred on it by an act of the National Assembly. The Constitution recognizes that the National Assembly can make laws on the jurisdiction of a court. And also, if we consider section 252 subsection 1 as well, he said that for the purpose of exercising any jurisdiction conferred upon it by this Constitution, or as may be conferred by an act of the National Assembly, which then tells us that the Constitution actually envisages that the National Assembly can make a law to complement the Constitution. It is settled law that the National Assembly cannot make a law to compete or to go contrary to the Constitution. What we're saying is that this section 396 subsection 7 is only a complementary provision, in the sense that it came to fill in that void where a judge has been elevated to another position. And I am submitting that the Constitution actually envisaged that there are circumstances where the National Assembly can do so. And I'm also submitting that when we take a broad view, or we use the purposive canon of interpretation, we take to look at what mischief the drafters of the Constitution and the drafters of the Act seek to achieve, and it is in the interest of justice. Another question that we want to pose is this: what do we call judicial activism? It is in areas like this where the ethos of judicial activism should actually be what one attunes one's mind to. Judicial activism is not judicial recklessness, as it has been established in Dalatu and Turaki. However, when we take this matter, when we put it on a scale of justice, the question is, where would justice tilt to? What would have happened? What is the worst thing that could have happened if the Supreme Court had given a broad and purposive view of Section 253? Would it have caused any form of injustice to Senator Orji? Of course no, because even the decision of the Supreme Court did not exonerate him. It's only just to say that no jurisdiction, so no injustice against him. Nothing, no form of injustice. But let us take it on the other side. What level of injustice will be occasioned with this decision of the Supreme Court? First is that 12 years is wasted. 12 years of effort wasted. 12 years of using the state resources wasted. The court should have looked at the end of justice. Now the court has said the whole matter, the whole conviction is void. And this has also engendered ugly heads rearing their heads. Now they are to start the case afresh, de novo. That means we will also start possibly another 12 years of intense litigation. 12 years of using state resources. What about witnesses? Those evidence. We should start all over again. This does not attune to the end of justice. The court should have given a liberal view of that provision. The court should have arrived at the conclusion that Section 396, subsection 7 of the ACJ is not in any way competing against the provision of the Constitution. We must give the law a human face, because the Constitution or the interpretation of the Constitution goes beyond the letters of the Constitution. It is the letters and the spirit of the law. So the court shouldn't have just considered the cold words of the Constitution. The court should have looked at the spirit behind those laws, especially as it relates to matters of social and practical realities. Now the matter is to start afresh. Several issues would then crop up. The issue of, what about the 5 months that he has spent in prison? Is he entitled to any form of remedy? Because where there is a wrong, there is a remedy. Because going by the decision of the Supreme Court, it then means that Senator Orji had suffered the wrong. Now the question of double jeopardy may also come up. Although, in my humble opinion, that cannot fly. Because the decision of the Supreme Court is that that trial was void. If it's void ab initio, it means that in the eyes of the law, there was no conviction. There was no wrong suffered. So it then means that he cannot plead section 36 subsection 9 and he may not be entitled to remedy. But then, for a group such as Senator Orji, it will not be surprising if this matter is actually raised in this fresh proceeding simply to just waste time, simply to tarry a little while, simply to mark out time. The decision of the Supreme Court, left to me, correct in principle it may seem, but I'm saying that it appears, sounds, and looks wrong, because the Supreme Court could have actually turned their eyes to the other side to the end of justice. This is my humble view. Thank you. I remain Yusuf Oluwafemi Salapo.